Picture a polling place in the American South, sometime before 1966. There is a line at the door, and before anyone hands you a ballot, they ask you for money, not a bribe, a tax, a poll tax, $1, maybe $1.50, and in some states not just this year's dollar but the dollars you never paid in the years you did not vote, all of it owed at once. Pay it, and you vote. Fail to pay it, and you do not. No matter how long you have lived on that street, no matter how much you care, no matter whose name is on the ballot, the tax is the gate, and money is the key. And that was the point. It was a device for deciding, quietly in advance, who would be allowed to have a say. This is Do It for the Case Law. Doctrine Deep Dive Season 0, the amendments, one at a time, one sharpest gap each. Today, the 24th. In 1964, the country changed its own constitution to shut that gate. The 24th Amendment was ratified, and in plain language it said the right to vote could no longer be denied because a citizen failed to pay a poll tax. That should have been the end of the story. But it was not, because the amendment carried a boundary inside its own text. And on the far side of that boundary, the poll tax was still standing, still legal, still collecting, 2 years later. So here is the question for this primer. The 24th Amendment banned the poll tax. Why did it still take the Supreme Court, 2 years afterward, to actually finish the job? And then a second question which almost nobody asks, and which turns out to be live right now. Is it finished? Start with what a poll tax actually was, because the name misleads people. It is not a tax on polls in the sense of surveys or opinion taking. Poll is an old word for head, and a poll tax is a tax by the head. A flat charge laid on a person simply for being a person, the same amount whether you are rich or poor. States had levied taxes like that for a very long time as an ordinary way to raise a little revenue. But in the decades after Reconstruction, several southern states found a second use for it. Take that flat little tax and make paying it a condition of voting. Do that, and you have built a wealth filter around the ballot box without ever writing the word wealth into the law. It falls hardest on the people with the least, and by design and in plain effect, disproportionately on black citizens and the poor of every race. Right, and the mechanics made it worse than a single dollar sounds. Some states made the tax cumulative, so you owed not just the current year, but the unpaid years stacked up behind you, which means the longer you had been shut out, the more expensive it became to buy your way back in. The device compounded its own effect. Payment often came due months before an election, long before the campaigns were loud enough to make an ordinary person think about voting. So the deadline quietly passed for exactly the people least plugged in, and it typically required a trip to a government office, during working hours, to hand money to an official. Every one of those steps is a filter, and none of them appears in the text of the law. By the early 1960s, most of the country had walked away from all of this, but a handful of southern states still had a poll tax on the books and still chained it to the vote. The poll tax did not work alone either. It sat inside a whole family of devices built to thin the electorate. Literacy tests, complicated registration rules, and worse. Each one facially about something other than race or poverty, and each one aimed in practice at the same people. That is part of why the poll tax was so durable. On its face, it looked like a neutral revenue law. A tax like any other tax, which also helps explain the shape of the amendment that finally came for it. Reformers had tried for decades to abolish the poll tax by ordinary federal legislation, and kept stalling, in no small part over a genuinely hard constitutional question. How far can Congress reach into the elections a state runs for its own offices? Rather than fight that battle, the country reached for a constitutional amendment and aimed it at the ground where federal authority was least contestable. That partiality is written right into the words, and I want you to hear exactly what the amendment reaches, because the exact words are the whole story of this episode. The amendment says the right of citizens to vote shall not be denied or abridged by the United States or by any state, by reason of failure to pay any poll tax or other tax. That is strong, flat language. But read the clause that sits right in front of it. The clause that names which elections we are talking about. The right it protects is the right to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress. Now look at that list. Every single office on it is a federal office. That is the entire universe the amendment covers, and it is a federal universe. The ratification itself tells you something about how contested this still was. Congress sent the amendment to the states in the summer of 1962, and it was ratified in January of 1964. Not slow by the standards of this season, but look at who did not ratify. Several states declined to act on it at all, and they were largely the same states still collecting the tax. One of them formally rejected it outright. That is the ordinary arithmetic of Article 5 doing its work. You do not need the states that are the problem. You need 3/4 of the whole, and the rest of the country supplied that. which is also a reminder of why the federal elections-only compromise was struck. The drafters were not writing for a country that agreed with them. They were assembling a supermajority, and every additional inch of scope was an additional reason for someone to vote no, which means the boundary is defined by what the list leaves out. And what it leaves out is nearly everything else on your ballot. Your governor, your state legislature, your county sheriff, your city council, your school board, the local bond measure. The 24th Amendment, by its own terms, had nothing whatsoever to say about a poll tax hung on any of those. So think about what it actually accomplished. It did something real and immediate. It took the poll tax off the table for every federal race in the country, permanently. No state could ever again charge you to vote for president or for Congress. But a citizen in a state that still ran a poll tax could walk into the very same building, be handed the federal ballot for free, and then be told that to vote in the state and local races printed on the same day, at the same table, the tax was still due. 1 election day, 1 voter, 2 rules. Here is where the courts come in, and here is where you have to hold 2 different parts of the Constitution in your head at once. Because the finish did not come from the 24th Amendment at all. It came from the 14th. 2 years after ratification, the Supreme Court decided Harper versus Virginia Board of Elections. These were suits, in the court's own description, by Virginia residents to have declared unconstitutional Virginia's poll tax. Virginia still charged its own citizens a poll tax as a condition of voting in state elections. Precisely the elections the 24th Amendment did not touch. In fact, the trial court had thrown the case out. The 3-judge district court, feeling bound by the Supreme Court's own earlier decision, dismissed the complaint. So the question on appeal was whether anything else in the Constitution reached a state poll tax. There is one more piece of machinery worth putting on the table before we get to the court, because it explains the timing. The 24th has a second section, and it reads exactly like the second section of the other voting amendments. Congress shall have power to enforce this article by appropriate legislation. Congress has never enacted a major statute under that particular grant. What it did instead, the year after ratification, was pass the Voting Rights Act, which rested principally on the 15th Amendment. And that statute included a congressional finding that the poll tax abridged the right to vote, along with the direction to the Attorney General to bring suits challenging poll taxes in state elections. So the case that finished this job did not arrive by accident. Congress had just declared the state poll tax a problem and pointed the Justice Department at it. The court was answering a question the political branches had deliberately teed up. And the court found its answer not in the shiny new amendment about poll taxes, but in the old general guarantee of equal protection. Here is the holding, in the court's own words. A state violates the Equal Protection Clause of the 14th Amendment whenever it makes the affluence of the voter or payment of any fee an electoral standard. Voter qualifications have no relation to wealth nor to paying or not paying this or any other tax. Sit with what that does. The court did not say poll taxes in federal elections are banned. The amendment had already said that. It said something broader and rooted in a different place. That conditioning the vote on wealth, on the ability to pay any fee at all, violates equal protection, period. And the Equal Protection Clause binds the states in everything they do, including the state and local elections they run themselves. The court then explained why wealth simply cannot be a voting qualification, and again I am quoting. Wealth, like race, creed, or color, is not germane to one's ability to participate intelligently in the electoral process. Lines drawn on the basis of wealth or property, like those of race, are traditionally disfavored. That sentence is the engine of the whole decision. The state's legitimate interest when it comes to voting is limited to fixing qualifications, and how much money is in your pocket is not a qualification. It tells you nothing about whether you can cast an intelligent vote. It is, in the court's own word, not germane. So a line drawn on wealth is one of those constitutionally disfavored lines, and a poll tax is exactly such a line. It sorts the electorate by who can pay and who cannot, and then it turns that sorting into the difference between voting and not voting. To get there, the court had to clear something out of its own path, which is worth telling because it is the court reversing itself out loud. Decades earlier, in a case called Breedlove versus Suttles, the court had unanimously upheld a state poll tax as a condition of voting. It had, in Harper's own description, sanctioned its use as a prerequisite of voting. Harper does not tiptoe past that. It says, and I am quoting once more, to that extent the Breedlove case is overruled. Listen to the precision in that phrase. To that extent. The court was careful to say that a poll tax as an ordinary revenue measure, a tax by the head levied to raise money, remains a familiar and perfectly valid form of taxation. What it can no longer be is a condition on the franchise. The tax may live. The tax used as a gate to the ballot dies. And that overruling marks a genuine shift in how the court looked at the poll tax, not just a change in who won. Breedlove had treated a poll tax as garden-variety economic regulation. The kind of ordinary revenue choice courts leave almost entirely to the states. No hard questions asked. Harper refused to look at it that way any longer. Once a state draws a wealth line around something as basic as the right to vote, the usual deference falls away because these are lines the Constitution traditionally disfavors. So it is not merely that the result flipped, the lens changed. A poll tax stopped being an economic policy the court would wave through and became a restriction on a fundamental right the court would look at hard and here strike down. Which is where most tellings of this story stop. Amendment plus case, gate shut, done. It is not done. And the reason it is not done is that the question came back wearing different clothes. Here is the modern version. A great many states strip the right to vote from people convicted of felonies, and then provide some path to getting it back.
Next given has been constitutional for a long time, and it is not what is contested.
The contested part is what the path requires. Because in a number of states the path runs through money, complete your sentence, and also pay the fines, the restitution, the court costs, and the administrative fees attached to your case. Pay all of it, and your vote comes back. Fail to pay, and it does not. So ask the question this episode has been building toward. Is that a poll tax? That question got its most thorough answer in Florida, and the answer may surprise you. Florida's voters amended their state constitution to restore voting rights to most people who had completed their felony sentences. The legislature then passed an implementing statute reading completion of sentence to include all the financial terms, fines, restitution, costs, and fees. A group of affected citizens sued. They argued the requirement violated equal protection as applied to people who genuinely could not afford to pay, and that it imposed a tax on voting in violation of the 24th Amendment. The district court agreed with them and entered an injunction. The 11th Circuit, sitting as a full court, reversed. That decision came down in 2020, and it is the most important thing to happen to this amendment since Harper. Start with what the court conceded, because it did concede something. It agreed that the 24th Amendment applies to felon reenfranchisement at all. Florida had argued that people who have forfeited the vote cannot raise a 24th Amendment claim until it is restored, and the court rejected that. States may deny all felons the right to vote, the court said, but they may not discriminate among felons by extending the franchise to some and denying it to others by reason of their failure to pay a tax. So the amendment is in play. A state cannot get around it simply by disenfranchising first and selling the vote back, and the court agreed that it would plainly violate the amendment to reenfranchise only those felons who pay a poll tax. A tax on the franchise itself. Then it held against the plaintiffs anyway. On two independent grounds. The first is about the word tax. The court drew a line between taxes, which are exactions imposed to raise revenue, and other monetary obligations the government imposes for other reasons. Fines are punishment for a crime. Restitution compensates victims. Neither of those is a tax under any fair reading of that word, and the plaintiffs did not really argue otherwise. The harder question was court costs and administrative fees, and the court held those are not taxes either, because they are legitimate parts of a criminal sentence, part of the debt to society that a person owes for a crime, rather than a revenue measure imposed on the population generally. The holding in the court's own words, fees and costs imposed in a criminal sentence are not taxes under the 24th Amendment. The second ground is the one that should make you sit up, because it turns on grammar. The court said that even if the fees were taxes, the claim would still fail, because of the specific words the 24th Amendment uses to connect the money to the denial of the vote. The amendment says the right to vote shall not be denied by reason of failure to pay any poll tax or other tax. The plaintiffs argued that means but for causation. If you would have gotten your vote back except for the unpaid fees, the state denied it by reason of the failure to pay. The court said no, and it reached that conclusion by comparing the amendment to its siblings. Right, and this is where it gets genuinely interesting, because it cuts against something this season has said before. We have noted, correctly, that the voting amendments are written in nearly identical grammar. The 15th forbids denial on account of race, the 19th on account of sex, the 26th on account of age. The 11th Circuit pointed at the one that is different. The 24th does not say on account of, it says by reason of failure to pay. And the court read that difference as doing real work, on account of a status you have, versus by reason of an action you failed to take. The other amendments name a characteristic. This one names an omission. From that textual difference, the court concluded that but for causation is not the standard, and that a financial obligation which indirectly burdens voting is permissible when the state has a constitutionally legitimate reason for the qualification that creates the burden. Whether you find that persuasive is genuinely contestable, and the case drew substantial disagreement within the court itself. But notice what it means for our story. Harper said a state violates equal protection whenever it makes the affluence of the voter or payment of any fee an electoral standard. That is about as broad as a sentence gets. And yet, in 2020, a full federal court of appeals upheld a scheme in which whether you can vote turns on whether you can pay. The distinguishing move is that these plaintiffs had been lawfully disenfranchised first, So the state was not conditioning an existing right on wealth, it was setting terms for restoring one it had already taken. That is a real distinction. It is also, in practical effect, a place where money decides who votes, roughly 60 years after the country amended the Constitution to stop exactly that. So here's the thesis, and it now has 3 parts rather than the usual 2. The right to vote free of a poll tax was built by 2 different constitutional instruments, each doing a separate half of the job. The 24th Amendment did the federal half. A targeted textual strike that named the poll tax and killed it, but only in the elections its own words listed. The 14th Amendment's Equal Protection Clause, as the court read it in Harper, did the state half. Not by naming poll taxes at all, but by declaring that wealth can never be a qualification for voting in any election a state chooses to run. Lay the 2 side by side and the gate is shut everywhere. Pull either one out and it is not. Notice the shape of that because it is the part worth carrying out of the episode. We tend to picture the Constitution ending a practice the way you would swat a fly. In one place cleanly, with one instrument built for the purpose. The poll tax story refuses to behave that way. Here the written amendment, the thing designed specifically and only to kill the poll tax, turned out to be the narrower tool, fenced into federal elections by its own careful little list of offices. And the broader, older, far more general guarantee, equal protection, which does not mention poll taxes or voting fees or wealth anywhere in its text, turned out to be the tool that reached the furthest. The specific provision solved the named problem inside a bounded arena. The general principle solved the same problem everywhere else. And then the third part, which is the reason this episode does not end where the tidy version ends. The same interpretive freedom that let doctrine reach past the amendment's words in 1966 also lets doctrine draw lines the words do not obviously contain. Harper's sweeping language about affluence and fees did not settle the modern question. A court reading the 24th Amendment closely found a distinction in the phrase by reason of, and a court reading Harper closely found a distinction between conditioning a right you hold and setting terms for restoring a right you lost. Neither of those distinctions is visible on the face of anything. Both of them decide whether real people can vote. So the doctrine that finished the job is the same doctrine that is now drawing new boundaries around it. That is not a betrayal of the text. It is what happens when general principles have to meet specific facts over and over for 60 years. That is the pattern this whole season keeps circling back to, stated as precisely as I can put it. The words of a provision and the doctrine the courts build on top of them are 2 different things, and a right very often lives in the space between them. Sometimes the doctrine quietly shrinks what the words seem to promise. Sometimes, as in Harper, it runs the other way and reaches past what the amendment's words were willing to say. And sometimes, decades later, it does both at once. If you want to know what a constitutional right actually protects, you cannot stop at the sentence printed in the document. You cannot stop at the landmark case either. You have to follow it all the way down, into the courts that are applying it this year. That is the sample. A full Amendment 24 season on this show would take the whole story a layer deeper. The history of the poll tax as an instrument of disenfranchisement and the long campaign to ratify the amendment. The deliberate decision to limit the text to federal elections and what that compromise cost. The equal protection road the court took in Harper and the precedent it had to overrule to get down it. And then, the modern arc in full. The legal financial obligation cases across several states, the disagreement inside the 11th Circuit, the parallel litigation in state courts, and the question of whether the Supreme Court will ever take up whether money may decide who gets a vote back. Each doctrinal question its own episode, each one anchored in cases we verify, not cases we half remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do in any situation of your own. And everything is built on real, named, verified cases. The holding in Harper versus Virginia Board of Elections was pulled from the court's own opinion before I wrote a single word, and so was the modern appellate decision on fines and fees, including the passage where that court states its holding in its own voice. Every citation is in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.